Welcome to Learn Student Typing with VIKAS Sir. Exercise number 55. Real Judgement 605 words at the rate 100 word per minute. So be ready. Start. Learned counsel further argued that the impunged judgment is not sustainable as the masony profits oblique damages awarded to the respondents is not based on evidence but only on conjecture in the name of taking judicial notice. It is argued that the judicial notice is to be taken only of increase in rent year to year generally, but judicial notice of absolute rental values cannot be taken. In support of his arguments, learned counsel has relied upon the judgment of this court, Electronic Co Limited versus Motion Pictures Association. Learned counsel submitted that even the rental in the year 2005 for an independent residential property in South Extension Part 1 area was rupees 75,000 per month. The rental for an apartment of 2500 square feet covered area is rupees 60,000 per month or rupees 24 per square feet. Learned counsel for the applicant also points out that the rent from rupees 14-15 per square feet has been increased to rupees 16 per square feet, where the property being residential property and being misused as commercial property, the rent cannot be more than rupees 15 per square feet. Learned counsel contended that the future masony profit awarded at the rate 1.75 lakh per month by the learned trial court is exorbitant and on the higher side. Learned counsel for the respondents, on the other hand, has argued that the documents adduced by the applicant in support of his case are fabricated stock. Here, learned counsel for the parties and perused the documents relied upon and lower court record. The applicant was paying rupees 90,000 per month at the rate rupees 15 square feet when the lease did expired on June 30, 1999. It is not in dispute that the applicant paid full monthly rental up to 13/11/2002 when the possession was handed over. In the instant case, the respondents have failed to adduce the evidence regarding the market rate of rent between the years 1999-2002. In the absence of any definite material showing market rate of rent of the suit property, this court has no option but to determine the masony profits by way of reasonable estimation. Next para. In the Judgement National Radio and Electronic case within bracket Supra, the question of judicial notice has been discussed, which clearly states that rent may vary due to number of factors. Nobody can deny the fact that there has been a rise in rent in Delhi and particularly in the area in which the suit property has been located. The respondent oblique plaintiff has produced 2 lease deeds for the evidence before the trial court of the properties pertaining to NDSE, second in respect of the commercial properties. The trial court has rightly rejected the lease deeds produced by the respondent oblique plaintiff with regard to commercial properties in the area NDSE. Second, because the rents in NDSE first, which are residential properties, are much lower than the rents in NDSE second, and there can be no parity with the properties located in NDSE second, which are commercial properties. The trial court has also rightly rejected the plea of the respondent oblique plaintiff that the property in question has been leased out to State Bank of India at the rate 3.71 lakh per month, and therefore they should be awarded the same amount from the applicants. The trial court has held that the suit property has been totally renovated, rebuilt, and modernization of the suit property was carried out as per the requirements of the State Bank of India, whereas no renovation was carried out and the construction of the suit premises was old and outdated while it was a possession of the applicants. So, the trial court has rightly rejected the plea of the respondent oblique plaintiff on the ground that the property in hand of the applicant oblique defendant was old and outdated. Full stop.